in session. Please be seated.
Good afternoon. This is the last case on the docket for the July 2020 session of the Court of Criminal Appeals in Nashville. And to my right is Judge Bobby Holloway from Columbia. To my left is Judge Tim Easter from Franklin. And I am Tommy Woodall from Dixon, Tennessee. Each side has 20 minutes. If you represent the appellant, you can reserve part of that time for rebuttal. And of course, we're under here. You can sit down if you want. We're here under unusual and unique circumstances. And I appreciate you coming and participating where we have live court. It's broadcast. The public gets to see it. Everybody's in the courtroom. You can sit, if you desire, you can sit right there and make your argument. I would ask that you make sure the microphone is pulled close enough so that you're heard on the speaker system, since we are being broadcast for the public, for people who can't be here. And if you need to remove your mask while you're talking, everybody is socially distant. There's nobody within 6 feet of anybody else in this room right now. You can take your mask off, but we do ask you to, when you're not addressing the court, if you would put your mask back on. But you can leave it on if you want to. If we have a hard time hearing you, we will let you know. But so far, now we've done this, counting June, this is the third day we've done this, and people who've used a mask, we haven't had a hard time hearing them as long as they talk into the microphone. Any other remarks that need to be made that you can think of? Okay. Call our case for this afternoon, please.
State of Tennessee versus Michael Domonic Sales.
All right.
Thank you. I will take it off temporarily.
Okay. You can.
It fogs my glasses.
It's okay if you want to sit down while
you.
you argue. If you're going to stay at the table, that we've been doing that. Most of the people have sat down while they argue under these circumstances.
Thank you, Your Honor.
Yes.
Russell Leonard for the appellant, defendant Michael Domonic Sales, Your Honor.
All right. Do you want some rebuttal time saved?
Your Honor, if I could just have 2 minutes.
2 minutes, okay. All right, you allowed to proceed. We're starting at 3:13, it looks like.
Thank you, Your Honor. As the court is well aware, this involves the death of a young man in Fayetteville, Tennessee. Mr. Michael Domonic Sales, the defendant, who right off the bat I'm going to tell the court, and I think it's pretty obvious from the pleadings, is a convicted felon. He was convicted of federal drug charges and had not been out of federal prison for a very long time at the time of these occurrences. Approximately a week before the event in Fayetteville, and I do not remember the exact date at this time, even though I've lived and breathed this for years, he was in a fight in a club in Tullahoma, Tennessee, actually jumped into the fight to protect a friend by the name of Travis Verge, and I think it was misspelled in some of the documents. And he was afraid of retribution because he knew and found out that most of the folks, if not all of the folks that they were fighting, were members of the Gangsters' Disciples, a gang that has apparently taken root from Chicago into this area and elsewhere. Mr. Sales, as a result, was carrying a weapon, which he shouldn't have been. He was a convicted felon, but he did. He carried a 6-shot, I think it was a .357 Magnum. On the night of this occurrence, his uncle, for one reason or another, took him to this club. The uncle being a local individual, Mr. Sales was not. He hadn't lived in Fayetteville since he was a young boy. Didn't know anything about the club, didn't know many of the people there. I think he identified 4 people that he actually knew when he went into that club. And actually, because he knew those people, he wanted to leave. And he called his girlfriend, Ina Draper, texted her from inside the club before the first occurrence of any hostility. Subsequently, on the dance floor, he had a bump in with Capone Carruth. And I hesitate to say, but I think the name Capone sort of speaks for itself. Somebody had an idea when they named the young man, unfortunately. But in any event, there were hostile words, and the two were separated. And Mr. Sales was taken to the front of the building. The dance floor was in the back of the building, and decided it was time to leave. And he left the building and was standing on the street trying to text his girlfriend, Ina Draper, again to say, come get me. He never got a chance to finish that text because he was followed immediately out of the door by Raphael Ford, Corey Eddings, Deshaun Askins, and one other, and at the moment I don't remember. All 4 of whom he knew to be members of Gangster's Disciples. At that point, subsequently, Mr. Capone Carruth, one of the 2 youngest people probably at that party, I think they were both under the age of 21, he and his cousin Kanan Johnson, the one that my client referred to as the light-skinned dude in the proceedings. He didn't know either of them. Mr. Capone Carruth followed the others out. And then out came Kanan Johnson, and Kanan Johnson handed something to Capone, and Capone made his way sort of in a circular motion around toward Deshaun Askins' side of the U that had been formed around Mr. Sales. Mr. Sales could not see what had been handed to Capone. It was obscured by, I don't know, I think he said one of the individuals that was out there sort of semi-obscured his view of the young man, but he felt that it was a weapon. He was scared. And so he pulled his weapon from the waistband and on the run, shot under his left arm. Didn't even know he'd shot the young man until the next day when he read the paper. The bottom line, that within a matter of a very short period of time and before he went to trial, some of these same folks murdered his mother in Shelbyville, Tennessee. Went looking for him, didn't find him, decided to take out justice on the mother, put a bullet in her head. One of the young men happened to be a cousin who had eaten at the lady's table during his lifetime. It's a strange mix. The other problem we have here is that supposedly everybody was searched at this party for weapons. And one of the witnesses who happens to be an employee and friend of the owner of the club, Carlton Carruth, is the one who was supposedly doing some of the searching. But Mr. Sales had a gun in his waistband. To cut to the chase, the young man died. Mr. Sales ran away almost instantaneously. Within seconds, he hears shots fired behind him, toward him. He shoots his gun into the air and keeps on running and disappears. Later, he does not tell his girlfriend immediately what's transpired. Later, he throws the weapon in the river. The bottom line is Mr. Sales was afraid for his life. When we went to trial, everything came out. We tried to elicit from the witnesses that they were in fact members of the Gangster's Disciples. The state's key witness, Corey Eddings, would not address anybody else being a member other than himself, having been a former member. On the periphery, I think is what he said. And from my knowledge of gangs, that just does not occur. You're either in or you're out, and usually if you go out, you get beat out. Bottom line, he would not address who was a member of the Gangster's Disciples. He said you'd have to ask them. He avoided it. It was, I guess, what we call a passive misrepresentation. But none of the other people who were questioned after he was questioned admitted to being Gangster's Disciples either. Not Raphael Ford, no one. Kanan Johnson denied that his cousin Capone was a member of the G's. Subsequently, and we tried to get it in every way known to man, and I failed this young man, and I hate to admit it, but I did. I should have somehow gotten this in, but I didn't. We tried to present Facebook evidence. It was denied. I got very frustrated with the process, but the bottom line is this never came to light except through my client. He is the only one that testified that all of the people that were out there surrounding him on the street, making him feel threatened, where he felt like he could not turn his back and walk away, they were all members of the gangster's disciples. He thought he was going to be shot. He didn't see a gun, but he saw something handed and he didn't know what to do. My argument is, one, we have some prosecutorial misconduct in the fact that I cannot believe that this same district attorney's offices did not know at the time of this trial that gangsters' disciples were involved in what transpired. Because in the next two trials, the Cavarius-Kelso trial and the Fletcher trial, both of which dealt with the murder of Mr. Sale's mother, Corey Eddings takes the stand and basically, almost gleefully testifies as to everyone who was a member of the gangster's disciples. And as a result, they got both of these men convicted. But I cannot help but believe that that information was available to the district attorney's offices. We suspected it after Michael identified some of these people at trial. Prior to the trial, we did not know he knew that some of these people were gangsters' disciples. So in the middle of the trial, we're picking up on the fact that we know this, or he knows this, and we can't get it in. The DA's office did not let us know that this involved gang-related activity or that gang members were involved. I think it was an ethical breach. I think I read an ethical opinion very recently, opinion 2017 F-163, that seems to address that very thing. The bottom line is, between that and his writ of error quorum nobis, which was denied, we think Mr. Sales is entitled to a new trial. The writ identified the fact that a misrepresentation was purposefully made by Corey Eddings when he testified from the stand that it was none of his business who were the G's, that I'd have to ask each one of them. He knew what he was doing. Then when he comes to the other two trials, Capone Carruth, the dead boy, is not the choir boy that he was made out to be by the district attorney's offices and his mother during the course of the trial. Kanan Johnson, who testified, who gave an early statement that he took his cousin in his arms, which meant he had to have gotten him up off the concrete, which meant that he did in fact fall face forward as the coroner said he did and was rolled over, changed his testimony in the course of the trial to say that he didn't touch him. We believe the gun was underneath him. We believe that's where the gun came from. He fell down with the gun underneath him. They rolled him over to get the gun, and immediately bullets are flying behind Mr. Sales. Now, apparently, this is a vicious group. Obviously, they murdered a woman over it. Why they wanted to kill Mr. Sales over a fight, I don't know. But apparently, he felt like it was coming. He said he had received an Instagram or something that had indicated a threat to him over what took place in that fight in Tullahoma.
Mr. Russell, it's hard to tell whose question it's way over here.
I'm sorry.
That's fine. Did any witnesses support the version that you just gave for the defendant, for Mr. Sales?
Not one.
And didn't numerous witnesses, some of which may have been in the gangs, some of which may not have been, testify fairly consistently to a different version where Mr. Sales was the aggressor, went through a crowd, stuck the pistol in the victim's face and shot him?
Yes, Your Honor, every one of them did. However, as I identified in my reply brief, Tony Brown was an employee and friend of the owner of the club who was the father of the dead boy. He was standing inside the glass doors. He was not outside and could not have heard what transpired. He was not on the dance floor and could not have seen or heard what transpired. Shanita Small, who claimed she went to and held the body during the course of the trial, she was never even seen outside by anyone. She was a close friend of Capone Carruth's sisters, grew up with them, knew them, was tight with them, and obviously was tight with the gangster's disciples. The bottom line is not one person was there who would support Mr. Sales. Now, Capone Carruth's father, Carlton Carruth, is a local businessman and apparently a very powerful figure in some regards. I'm not exactly sure whether there's a connection other than his business or not, but nonetheless, he is a powerful figure in that community.
Isn't it up to the jury, based on you're seeking, and you raised an issue of judgment of acquittal, the trial court's failure to grant, which basically is sufficiency of the evidence. Isn't that a question for the jury, which of these witnesses to believe and not to believe?
Your Honor, obviously that is the way our system works. I wish it could have been tried in a different venue. I'm not sure it would have made any difference. But to try it in the home of the family of the young man, particularly knowing who the father was, I'm certain made it difficult for the witnesses to testify any other way than what they did. But yes, that is the way our system is supposed to work, Your Honor. There is no doubt. But the circumstances belie it. The gun, the .40 caliber gun, was used almost immediately after Mr. Sales shot the young man to fire upon him. Corey Eddings testified that a gun had been left for him just in case. He wouldn't go any further. The gun was, if the young man, if Kanan Johnson had to run to the car to get the weapon and run back, said he tried to put a bullet in the chamber, but he did not know how to shuck a pistol. Apparently, he had never fired one. So Corey Eddings said, toss it to him, so he tossed it to him. That part I don't doubt. But I don't believe in the turmoil and the shock of Capone being shot instead of being the shooter. They immediately took the gun rather than going to him. But he was found on his back, Your Honor. He was not found in the position in which he fell, face forward. There's something that just doesn't pass the smell test.
Is there anything that you've argued here this afternoon different from what you argued in front of that jury?
I did not have the opportunity to argue the fact that the truth of the affiliation with the gangster's disciples was an element that should have been known to the jury. This boy was painted as a college boy, a hardworking, industrious young man. There was nothing indicative of him being a gangster's disciple, a member of a very seriously dangerous gang.
There was gang evidence introduced.
Most of the gang evidence introduced was actually against my client. My client is the only one who said, yes, Raphael Ford's a gangster. Yes, Corey Eddings is a gangster. Corey Eddings identified himself as one in the past, no longer, but didn't know anybody else who was. No one identified any gangster's disciples except my client, Michael Domonic Sales, the defendant. And the defendant in the chair in front of this jury, the likelihood that his solitary testimony as to who is and was a member of this gang is likely to be believed. That's the problem I have. I could not get that in this jury trial.
Did either side file motions to exclude evidence of gang activity?
There were no motions filed. However, I tried to get in evidence, Facebook evidence, and it was denied. And quite candidly, I probably did not do it properly. But we didn't find out until in the middle of the trial that there was actually serious gang activity involved in the trial. Actually, I take that back because I want to be thoroughly honest. I did find out at one time that some member of the G's had threatened Maisha Pullen, that they were going to kill her if she testified. And she was pregnant, and she's a little bitty girl, and she was terrified. And as a result, she changed her testimony, and I did not call her as a result. that was the first instance of my having any idea that gangster activity was involved. I didn't know how deep it went. I didn't know where it was going to go. And it very well may have been my fault. I'm not afraid to say that looking back through the transcript, I made some mistakes in this trial. There's no doubt. But I think I was also the defense was taken advantage of. We were not given the information that we had a right to know that this was gang related. As a matter of fact, I think General Filer made a statement during her closing argument that there was nothing that indicated that there was a gang-related activity involved in this. The judge, however, was he felt like there was, but we couldn't get the evidence in. And the fact that Corey Eddings said, I can't answer that, you're gonna have to get your answer somewhere else in so many words, might have told the jury they're not gang members. And then when they stood up and denied being gang members under examination, that sort of sealed the deal for the jury.
You're starting to get into your 2 minutes of rebuttal.
Yes, Your Honor. And I won't take but a moment longer. The bottom line, Your Honors, is that I feel that had we known and had it been made known to the jury that Capone Carruth and his affiliated friends were members of the Gangsters' Disciples, there might have been a totally different verdict in this case. That it might have been perceived that the gun came from underneath Capone Carruth, that it was actually handed to him. I also firmly believe that the denial of that evidence might have made a difference. And if it might have made a difference, I think it falls within the four corners of the writ. Thank you, Your Honor.
Okay. Oh,
Good
go
afternoon,
ahead.
Your Honors.
Go ahead.
Thanks a lot. Austin Watkins again here, appearing on behalf of the state of Tennessee in this a little bit of an unusual case. As this court's aware, we have a direct appeal as well as a joint error quorum nobis appeal. So we kind of have a large record with two different kind of procedural postures here. The state's position, real briefly, is that the judgment should be affirmed for two reasons. First, there is sufficient evidence that the defendant shot the victim out of premeditation and not in self-defense. And then second, the handful of prosecutorial misconduct claims have been waived in the trial court, and there's defendant's not entitled to plain error review or plain error relief on appeal. And then separately, with regard to the petition for writ of error quorum nobis, the record reflects that the trial court properly exercised its discretion in denying error quorum nobis relief because the defendant did not present newly discovered evidence that may have affected the outcome of his trial. Before I turn to my first point, Your Honor, about the sufficiency of the evidence, what I did want to kind of try to do real briefly is narrow the scope of what this appeal is about. It's not a post-conviction appeal. There aren't any allegations of ineffective assistance at trial counsel before the court. There's also not any Brady allegations before the court. What is before the court at this point is a sufficiency of the evidence claim, a couple of evidentiary / improper closing arguments claims that the defendant has called prosecutorial misconduct claims. And then we have this error quorum nobis question. And the error quorum nobis question is simply, based on the statutory standard for newly discovered evidence. So with that in mind, feel free to steer me to what the court thinks is the most important thing. But just to start, we've heard a lot about the defendant's version of the facts. As you all will imagine, the state's version of what happened is much different. The record shows that Mr. Sales showed up at this club, as opposing counsel has admitted, as a felon in possession of a firearm. He had a revolver, showed up at a party. He goes into the party and not just shows up with the revolver, but has to get through the makeshift security at that venue So he smuggles the weapon in. The eyewitness testimony is that he then becomes kind of aggressive and belligerent in the back room, and that culminates in him physically bumping into the victim, and they get into an exchange of words. There's a physical and a verbal kind of altercation there that ends up moving from inside the club to outside the club. At some point in that confrontation, the defendant challenges repeatedly the victim to fight him, and he ignored multiple attempts to de-escalate that confrontation. He did not leave the parking lot of the club. He then threatened to shoot the victim and proceeded to do so, shot him once in the head, fled, was in hiding for over a week, and then disposed of the revolver that he used to commit the murder. And Your Honors, if you look at all that together, there are multiple points at which the defendant had the opportunity, the motive, expressed his intent to commit premeditated murder, to act out of a deliberate conduct after having exercised reflection, and, you know, knew what he was doing. And Your Honors, the only evidence there was that he acted in self-defense was his own self-serving testimony at this trial. There were a lot of eyewitnesses who testified. It is a large record. They all said very similar things. And the inconsistencies in their testimony, Your Honor, the state suggests makes their testimonies carry that much more weight, because it seems likely that on the small details they didn't quite all get right, suggests that there wasn't some large conspiracy, that all of these people got together and unanimously said the defendant is the one who caused this problem, refused to be placated, and then right out in the open in the parking lot shot this young man in the head and then took off. And so, Your Honors, there's ample evidence under the Jackson standard for a rational jury to find that the defendant acted with premeditation in this case. Just briefly, a little bit more about the self-defense kind of argument that Your Honors have heard here. There was you know, the defendant shot under his arm, and that immediately someone returned fire, and that the victim's body was removed, and the evidence all shows what it shows. There was disputed testimony about whether the victim fell forward or fell backward. He had some chipped teeth, which the medical examiner kind of said indicated that that portion of his head at some point had hit the ground, most likely. But there was no weapon recovered from the vicinity of the victim's body. There were bystanders, I say bystanders loosely, in that some of the victim's friends who had been out there kind of watching what was happening, they had gone to get a retrieval weapon from a parked car on the other side of the building once the defendant threatened to shoot the victim. So as that weapon's going to be retrieved, then the shooting happens. And if I remember correctly, Your Honors, the shell casings that the officers found when they investigated the crime scene were not in the vicinity of where the actual shooting took place of the victim. So it would have shown not that the gun was picked up from the victim and then shot at the defendant. It would have had to have been off on the other side of the building, which corroborates the multiple witnesses' testimony of the timeline of how everything played out. And so that's all laid out there in the record, Your Honors. And ultimately, even if you kind of look at what the defendant's testimony was, it really doesn't even make a legitimate claim for self-defense. He can be fearful, but he testified that he never saw a weapon. He just got nervous and eventually decided to shoot the victim. And so based on all of the state's proof about what happened and who started it and how it eventually went down, there is ample evidence of premeditation here to survive appellate review of the jury's fact-finding decisions here. Moving on then briefly to these claims of prosecutorial misconduct. Your Honors, basically in defendant's brief, there's two specific allegations that the prosecutor improperly elicited gang affiliation testimony. And then there are two separate arguments that it's two different prosecutors, but during the state's opening or principal closing argument, it misstated the evidence, and then in the state's rebuttal argument, it improperly misstated the law on self-defense. As laid out in the state's brief, Your Honors, all of these claims are waived because there either wasn't a contemporaneous objection at trial during the alleged error. And most, if not all, were not raised in the motion, or not, if not all, most of them were not raised in the motion for new trial. One of the issues was. Moving real briefly into this eliciting of the gang affiliation claims, the entire self-defense theory was gang affiliation. I'm not a gang member, they're gang members. I was afraid, they started this, they threatened me, I couldn't get away, so I shot them. That was the entire self-defense theory, and self-defense was injected first by the defendant in his initial, one of his early cross-examinations, and then it happened throughout the entire trial. And so one of the things that happened then is on the redirect of Mr. Corey Eddings, who we'll hear a little bit more about later with regard to the writ of error quorum nobis. During cross-examination, defense counsel gets in there and starts asking him lots of questions about his gang affiliation. He admits he is a gang member, or was. And then after they kind of get into that exchange, on redirect examination, the prosecutor follows up and says, well, do you know if the defendant was also a gang member? There's a hearsay objection, not a prosecutorial misconduct or objection, or even a relevance objection, but that objection is sustained. So the answer to that question is struck, and then the prosecutor asked him, well, what, to your knowledge, was he a gang member? And then the answer is, well, all I know is he told the victim during the fight that I witnessed, I'm a Crip. So that is legitimate testimony, and it's well within the bounds of, redirect examination for prosecutor to come in when that door has been opened on cross-examination and to get into that, that evidence. So it's nowhere near close to prosecutorial misconduct. At most, it's maybe, a relevancy issue, so to speak, under Rule 403 of the Rules of Evidence. But generally, that is very all fair game. And then the other instance of kind of gang-related testimony that the defendant has complained about is that during the cross-examination of the defendant, after he's gotten up there and explained, I knew these guys were all gang members, and so here's why I did what I did. The prosecutor then comes in and asks him about his gang affiliation, especially after multiple witnesses have testified, well, you threatened to kill the victim because you were gang affiliated. And one of the, follow-up questions kind of at the end of the line of questioning from the prosecutor is about the defendant's familiarity with the colors of the gang that he allegedly would have been a part of, the Crips. And he says something about the color blue, and the prosecutor asks a follow-up question, like the color of the shirt you're wearing. And that in and of itself is a facially legitimate question where he's following up on the nature of the defendant's answer about his familiarity with gang, insignia and culture. Probably was a low probative value question. And the state's position is that there wasn't any unduly unfair, prejudice here with regard to that specific question. But those are the two kind of specific instances, Your Honors, in the defendant's brief about that gang evidence that shouldn't have come in. State's position, to be clear, is that it all was relevant, admissible, probative, proper questioning from the prosecutor with regard to, the defendant's no qualms about its self-defense theory. Moving on then to the improper closing argument claims. One of them regarding misstating the evidence. I've got the quote here, Your Honors, about what the prosecutor said at one point is, there really is not an iota of credible proof that this had anything whatsoever to do with gangs or, gang activities or anything about gangs. Again, this argument that's improper is waived because there wasn't a contemporaneous objection. This court and the Supreme Court has said multiple times, you've got to make your objections during closing argument. It also was not specifically raised in the motion for new trial. And essentially, if you look at the transcript in the context of the entire closing argument, the prosecutor is simply making a persuasive argument to the jury about the weight of the proof regarding gang affiliation of the victim and the witnesses. And that's fair game for the prosecutor. And the jury knew that it had heard all the evidence and could believe what it wanted to with regard to defendant's claim that this shooting was motivated out of self-defense, based on his perceived gang affiliation of the victim and several of the victim's friends who were nearby. So, Your Honors, that's not a proper argument. The last thing then is this discussion about the prosecutor misstating the law. And again, that was in rebuttal argument. And basically what the prosecutor told the jury is that, oh, he's made this argument that he acted in self-defense. Well, if you read the jury instructions, you have to be acting lawfully to use self-defense, and he was a felon in possession. So he can't use self-defense next. And so it's kind of a laundry list of things that the prosecutor was rebutting in that rebuttal closing argument. He touched on that briefly. Technically, the state admits was inconsistent with the subsequent decision of the Tennessee Supreme Court in Perrier. And so the state's position is that there was no remediable improper argument there because, that was the arguable law at the time. And the prosecutor couldn't have known any different. And then also, Your Honors, the jury actually received the correct instruction from the trial court that said the opposite of what the prosecutor said. The actual written jury instructions are in the record, and it says being a felon in possession does not mean that you are not able to use self-defense. And so, Your Honors, there's just under the judge factors that the case judge, there's just no reason for there to be any relief granted on that's what turned out to be a misstatement of law, but was accurate at the time. And so if there are no questions about the sufficiency claims or those evidentiary and improper closing argument claims, I'll move into the error quorum nobis issue.
I've got just a question
Yes, Your
about the statement by the prosecutor that he wasn't entitled at all to have self-defense.
Okay.
You said that at the time the prosecutor made it, the argument, it was not in contrary to what the law is, but you said that the trial court gave the correct statement of what the law is in the instruction, which is directly contrary to what the prosecutor said. And I don't know how they do it now, but years ago when I was trying criminal lawsuits, the trial judge, almost in every case I can think of, gave the attorneys the opportunity to look at the instructions. And I kind of find it, I think you argued in your brief, it's been a few days since I read it, but that the law was in flux during this time as to whether you were denied the right to not have to retreat, or were you denied the right to even assert self-defense? And so I'm a bit confused why the prosecutor should have a pass on this if the trial judge gave the correct, as you said, gave the correct statement of the law in the instructions. The prosecutor said something contrary to that. So why should we give I'm not saying it's reversible error, but why should we give the prosecutor a pass on that and just say the law was in flux and everything's okay?
Yes, Your Honor. I think your question implies that the prosecutor knowingly made an inaccurate statement of the law or an inconsistent statement of the law with the jury instructions. That might be true. I don't remember exactly what the order that's borne out in the record of how that discussion went about. Some trial courts, if I'm not mistaken, will instruct the jury before closing argument. Some will instruct them afterwards. I don't recall when a discussion among the court and counsel occurred about the language in the instructions. But Perrier, Your Honor, itself acknowledges, I believe, inconsistent decisions from this court about the duty to retreat and kind of the nature of, who should decide it and whether being a felon in possession in and of itself invalidates the use of self-defense. It says before it answers the question, this was murky area of the law. It is very unusual for there to be what I would consider to be a preemptive jury instruction, which is what happened. The trial court knew Perrier was in the pipeline, and I think out of an abundance of caution, put that language in there. And I don't know whether the parties and everyone had agreed on that before or after closing argument. I don't know, Your Honor. But it's possible the prosecutor was just kind of going off of what he had prepared before they'd had that discussion, or was just in the zone and was used to that being his self-defense argument.
If it was a minor issue in the case, I could accept a little bit of recklessness or negligence and not paying attention, but that was the main issue in the case. That there was no contest that the defendant shot the victim. The victim was hit in the head and died either immediately or pretty soon after that. And self-defense was the main issue. And it's hard for me to give a prosecutor a pass when what he argued was that the jury wasn't even entitled to let him consider self-defense.
Yes,
And that's directly contrary to what the charge. And I think the prosecutor ought to make an effort to make sure what the judge is going to charge on that.
Yes, Your Honor, the state understands your concern. And a couple things. The multifactorial analysis that kind of encompasses this error, it considers not just, the prosecutor's conduct, but several other things. One would point out, even though it kind of points that maybe the prosecutor should have known what jury instruction was going to be given, the jury instruction was proper, and that is good. And the jury also was instructed that the arguments of counsel were not the law. They were told, you have to read the law from the jury instructions. Third, as I mentioned, this was it's one or two sentences. It's a passing argument in the laundry list of things that prosecutor was responding to in his rebuttal closing argument. It wasn't the principal point of the closing or even the rebuttal. It was just in passing. And Your Honor, yes, the case was, the defendant's theory was I acted in self-defense. The state's proof was very strong. He provided no legitimate proof other than his own testimony that he acted out of self-defense. So yes, it was a colorable issue. They got the proper instruction. It's unfortunate that this error did happen, but Your Honors, I feel confident if you review the entire transcript and the record, you'll feel confident as well that it just really was a minor, misstatement that would not have affected the jury's verdict when it was trying to decide who instigated this altercation, Your Honor. Moving then real quickly, Your Honors, I'm not sure how much time I've got left. I wanted to address error quorum nobis. If I'm out of time and you don't want to hear about it, I'm happy to.
You've used up your time, but we've asked you some questions. So if you need a couple of minutes to talk about quorum nobis.
Your Honor, just very briefly then, and I appreciate that. The error quorum nobis claim is that Mr. Eddings, who was one of the witnesses presented by the state, who was present and observed the shooting, that he gave false testimony at the defendant's trial, and then subsequently at these two related but different trials testified for the state differently than the testimony he gave at the defendant's trial. And that specifically is related to the victim's alleged gang affiliation. The Supreme Court has outlined what the requirements are for recanted testimony to be considered newly discovered evidence under the error quorum nobis statute. And two particular prongs that are important here. The testimony given by the witness at issue has to be false, and the new testimony has to be true as determined by the error quorum nobis court. And then second, the defendant has to have shown that he was reasonably diligent in discovering that evidence, or that he was surprised by the testimony given at his trial and was unable to know of the falsity of the testimony at his own trial. So if he could have done something to combat the falsity, then it's not newly discovered evidence. And so after this is all laid out in the briefs and in the record about the subsequent testimony, basically at the defendant's trial, when Mr. Eddings, was cross-examined by defense counsel, he admitted that he was a gang member at the time of the shooting, but had since was on peripheral. And then he refused to answer questions about anyone else who might have been a gang member, including the victim. In subsequent trials for the murder of the retribution killing related to Mr. Sales' family, Mr. Eddings did, when he was questioned by the prosecution, identify other members of the gangster disciples. What the Air Quorum Nobis court said about his trial testimony here is that it was not false. He just simply refused to answer questions in this trial that he chose to answer later, and that therefore there's not an actual false testimony as required under Mixon to be, to make out a Air Quorum Nobis claim under these circumstances. And Your Honors, even if we accepted, for the sake of argument, that the testimony in this case was a misrepresentation or somehow fit into the false testimony mold, he still loses on the other prongs because he had reason to know about the victim's gang affiliation at trial, and that's borne out in the record because he detained a witness to offer testimony about the gang affiliation of the victim. And the record citations for that are in the brief. He chose not to call that witness ultimately, but the fact that he could have gotten in the proof that he claims this one witness could have testified to, you can't pick and choose his proof. If he had other means to get it in and he knew about it at the time of the trial, it's not newly discovered evidence for Air Quorum Nobis purposes. And again, ultimately, as the state has emphasized here with regard to sufficiency, with regard to any harmlessness of any errors that occurred, the state's case was very strong here because many witnesses testified very consistently about what happened. And there were a couple of witnesses who were not alleged to have been gang members. These were, the state used the term neutral witnesses in the state's brief. That may not have been the best word choice, but the implication is just that they're not alleged to have been essentially in the gang, kind of such that they would have had a stronger motivation to not testify truthfully. And so thank you for your times, Your Honors. If you have any more questions, happy to address them.
Thank you. You've got at least a minute left of your rebuttal time if you need to use it.
Thank you, Your Honor. Briefly, I'm going to beat you up and I'm going to shoot you in the head too. I have never, ever heard any people associated with gang talk like that. I don't know where it came from, but it did not come out of Mr. Sales' mouth. That's my belief. Second, the blue shirt. He was never a Crip. He said he had no gang affiliation. They knew he had no gang affiliation. He tried to leave. They followed him out of the building. That's crucial. The confrontation had been in the dance floor. They ushered him upstairs, but he himself was voluntarily leaving. He didn't feel comfortable there. He knew there was a problem. He knew it before the confrontation. He was trying to exit the building and he was surrounded. That's all I have for you.
Thank you. That concludes our court for today, doesn't it? All right, we'll be in recess until whatever days in August that we're supposed to be here. Okay.
Counsel.
Thank you.
All rise.